Hi guys. So this evening we will be discussing how to study for paper three. I want to help you prepare for paper three. This is one of the papers that many candidates struggle with, not because the work is impossible, honestly, but because I believe you don't know how to study for it properly. Hopefully, by the end of this chat, you will know how to approach each section and know how to make sure you're ready to pass, right? So, first of all, start with the right mindset. Paper three is not about memorizing the theory only. Like, you're not just going to load information and then pour it out in the exam. Né? The examiners want to see if you can apply legal knowledge in practice like a real attorney. So, as you study, don't just learn the law. Ask yourself, how do I explain this to a client? How would I draft necessary document in terms of your contracts? What practical issues could come up from this, right? That is the difference between passing and failing this paper. Let's start with Boss Zonke, drafting of contract. The golden rule for drafting of contract is understanding the purpose of the contract before you draft, right? For example, let's say a deed of sale, right? It transfers what ownership, whether movable or immovable. So the purpose is certainty of terms such as what is being transferred, what price, who are the parties, when does ownership pass, things like that, right? Come to another one, another example, for instance, your lease agreement. You know, a lease agreement creates a temporary right of use. But what if a tenant wants to buy later? What clause would you bring in? An option to purchase. What if in that option to purchase, you also have to give the other party can sell the property, but this person has the option to purchase. What else should be included? The right of first refusal, right? Because then it binds the landlord to sell if the tenant exercises it. So a right of first refusal means basically the landlord must offer the property to the tenant before selling it to anyone else because the tenant has the option to purchase the property. Another example of a contract, acknowledgement of debt. We know it secures what? Repayment. So you have to include clauses like the repayment terms, what is being acknowledged, the amount that is being acknowledged, what serves as proof of indebtedness, what do we consider breach? In terms of breach, what is the remedy? Things like that. And then now let's talk about your boilerplate clauses. These are clauses that are standard, right? Everything is there. Like you usually find them in a lot of contracts, like your parties, variation, non-variation clauses, force majeure, dispute resolution, things like that, right? Your suspensive condition. When can a suspensive condition come into play? When something is subject to something, they give you a scenario and then they tell you that the agreement is that um, the party ownership will move if 1, 2, 3 comes into existence, right, or close to that effect. Then you should know that, okay, ownership is suspended until 1, 2, 3 comes into existence. That is what a suspensive condition. So don't memorize, practice explaining each clause in plain English as if you're advising a client. Come up with scenarios against a clause. That is how you will master contract drafting. And then we move on to matrimonial, right? We know matrimonial mostly is marital regimes in community of property, joint estate, everything is shared. Out with accrual, separate estates, no sharing of growth. Um, then out without accrual, it's completely separate. So the first one, it's out with accrual. It's obviously everything that grows in the estate is ours, but everything before it's separate. Now out without accrual, everything is completely separate. Know the consequences of divorce. The any everything surrounding the best interest of the child. In case they tell you that, write the part of what's this custody care in terms of a child, that clause in the particulars of claim, know how to draft that, how you would ask for prayers to that effect. Know your interim applications in terms of where there's divorce proceedings going on that interim maintenance application. And then know your customary law before the Recognition of Marriages Act, that women did not have equal rights in terms of property. And then after the act, now that women um, have equal status and capacity, rights to own and deal with property, and then monogamous customary marriages are automatically in community of property unless we've got an anti-nuptial contract that excludes it. And then for polygamous marriages, the husband must apply to court for approval of a written contract regulating now the new marriage that they want to enter into. If the other spouse did not consent, as well as it was not properly approved by court, then it cannot have effect. It's an invalid marriage. So what was the effect of the customary Act, the Recognition of Customary Marriages Act? The rights of women have been strengthened and no more inferior status in marriages. Women basically have the same legal capacity to act. Sorry, guys. Ugh, I have my own notes in paper. I forgot to scroll here. And then the labor dispute resolution, right? Um, okay, we've done with this. Labor dispute resolution. Know your basics under. Hold on, guys. No, my love, I'll be with you just now. So know your basics under Labor Relations Act. Dismiss or substantively and procedurally fair. Unfair labor practices, strikes and lockouts. Know your difference. What is a protected strike? What is an unprotected strike? Um, know key processes in your CCMA conciliation, then arbitration. Also remember transfer for business in terms of Section 197, they like that a lot, although we didn't have it in March 2024, 2025, but really, this, I think there are 6 or 7 things that you need to that are fall under Section 197 when selling a business as a going concern. Basically, that the employees in their contract automatically transferred to the new employer on the same terms. For instance, if shop A is sold to shop B, the workers continue their employment contract with shop B, same contract, same benefits. You cannot dismiss employee just because of the sale of the business. Ask yourself, for instance, from your past papers and practice scenario, ask yourself, what should happen under a sale of a business as a going concern? And if they don't do that, what would that be considered as an unfair labor practice, right? Let's say someone wants to buy a business as a going concern, and then they ask you to advise them, maybe they want to dismiss or have new employees. You would then bring up your 7 things and advise that in terms of the Labor Relations Act, and if business is being sold as a going concern, these are the terms, this cannot be changed, blah, blah, blah. As in terms of those, I think it's 7 or 8, not so sure, but you guys will look at the act. And then we go to information and cyber law, right? So we've got, under your information and cyber, we've got the Electronic Communications and Transactions Act, which deals with the validity of e-contracts, electronic signatures. Under this one, they give you the contract, the things that can be signed electronically and which cannot. The LPC likes that question. So please know what can be signed electronically and what cannot. Also understand POPI, protecting personal information, cybersecurity, preventing fraudulent transfer, phishing, and email hacking. I think it's the ENS case, if I'm not mistaken, one of the big fours. Look at that case to understand also what the effect of having business bank accounts change fraudulently or a client. I know that case when I was studying, but I can't remember it now. But also just read that case to understand the importance of cyber. Coming to professional legal ethics, this is not just common sense. You must know the LPC's code of conduct, right? Like this one, you must know. Understand what conflict of interest is. There's a scenario that they used to like in terms of, let's say, you're representing two people, their vision are conflicting, and then the vision of the other may incriminate the other, what would you do? It's either you recuse yourself from both, from representing both, or you stick with one, something to that effect. It's on a lot of past papers. Confidentiality and privilege. Understand the importance of protecting client information, and legal professional privilege, overreaching and undercharging. Understand these, both of them are misconduct, right? So understand what the difference between overreaching and undercharging. Advertising, the LPC is very strict in terms of how you advertise. Previously, they had given a scenario that dealt with a law firm and something to do with printing. Then you had to advise whether this advertising technique is okay, is acceptable or something. Obviously, a law firm being advertised together in a sentence that has to do with printing, it's unacceptable. If you're a law firm, you have to be a law firm. You cannot now advertise also your printing services. So that such advertising wouldn't be acceptable for the purpose of the LPC, right? And then calling yourself an expert. The LPC says that you cannot call yourself a specialist unless the LPC has consented to that. So if you call yourself an expert, the LPC wants to see why you're an expert. So you'd have to obviously consult with the LPC in that regard. I think they there's something to that effect in your code of conduct. Also remember that in case they ask you a scenario that so and so calls them an expert, is it permissible? Then you'd obviously have to start. And according to the code of conduct, um, before you can regard yourself as an expert, this is what must happen. This is what you must consult the LPC, blah, blah, blah. And then sharing of offices, right? They can give you a scenario that you are a law firm owner, your wife has a coffee shop. Can those two be in the same building? Unfortunately, they cannot be in the same office, right? You only share your premises are only limited to you being a legal practice. You cannot run a coffee shop as well as a law practice in the same office. That is not permitted. That is not permissible in terms of the code of conduct of the LPC. And then sharing of fees, you cannot share fees, right? It's only allowed in certain circumstances, but generally attorneys are not allowed to share fees with anyone. You do not go out and then when you pay police officers to refer clients to you and share fees with them. Unfortunately, it is not allowed. It's considered misconduct. And then you go to your legal costs, know your party and particular costs, attorney and client, attorney and own client, the bonus properties, all those types of costs, know them and when they would apply. Do not just know them in terms of definition. Also know if they give you a scenario and say Sheila acted grossly as an attorney, negligently, whatever, 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 which cost can the court order against Sheila? Know that okay, it would be the bonus properties because Sheila was very negligent. The conduct is not acceptable in terms of her being an attorney and things like that. Learn your contingency fee agreement, the two differences, which amount, the two options, that amount or this amount. You guys learned that by now. Now going to practice management. This module deals with how to run a firm. You register with the LPC, you obtain your Fidelity Fund certificate, you open business and trust account, the importance of keeping the two separate, put risk management in place, your FICA, your POPI, fraud, cyber fraud safeguards. And then it also deals with closing of a practice. How do you close a practice? You notify the LPC. You properly deal with your trust money transfer to the different people that have money in their trust, return client files and property, settle accounts and keep records and things like that. And also just to revise, ask yourselves to say that if I open my own firm tomorrow, what steps must I take? If I closed my firm, what steps must I take, right? And then that's the long and short of it, guys. Use the syllabus as your checklist. Like just here, I used the syllabus and explained the important aspects of the module. Now, don't rely on papers alone. Every topic listed is a fair game, trust me. You can get a question or not. Study with examples. Turn principles into scenarios. That's how examiners test you. Sometimes you've got the information, but you don't know how to communicate the information because you do not test yourself with principles and scenarios. You only relied on the theory and thought they will ask you specific things, but in the exam, it's scenarios. A contract clause, draft while you study. Your fee agreements, um, boilerplate and don't just read. Learn how to draft them and draft them in your own words. And then summarize. Keep one pages on boilerplate clauses, your matrimonial law, cyber law processes, as well as ethic rules. So what I did when I was studying, I would take the whole module, right? Summarize everything that I remember in terms of that module. And when I mean everything, I mean everything. Like I would close my book and then write everything that comes to mind in terms of the clauses that I can remember, all clauses that I can remember, and then write all the purpose of the contract. Like each contract, I would write its purpose and all contracts that I remember, and then go to matrimonial law, write everything that I remember in terms of matrimonial law, like everything. Everything that comes to mind in terms of matrimonial, I write it down. Same goes for labor. Same goes for your ethics, information practice management, as well as cyber. This is to make sure that your brain is retaining information and see what is it that you are able to retain in terms of the module, so that if you go back to your notes and you see that, oh, this is a section of matrimonial that I forgot, you need to go back and revise it. And then again, write everything in summary that you remember in terms of in terms of that module. And then okay, my love, can put that on your pimples. Guys, my daughter believes that she's got pimples and she's 4 anyway. To each his own. Nonetheless, and then coming to management of time. In the exam, plan your answers. 25-mark question should be about 45 minutes. Pace yourself now and learn how to answer quick, but also do not allow yourself to panic because panicking causes a mind block. You could see a question and be like, I know this, but your brain is not coming to the party. So please keep calm. Also practice time management. To pass paper 3, really the long and short of it is you need more knowledge. You need application. Understand the purpose behind each module, each topic. Practice drafting. This is not the drafting for paper 1. Drafting in terms of writing clauses. Think like an attorney and while advising a client. In terms of professional legal ethics, think like an attorney of what, in terms of what the LPC expects from you as the attorney. The examiners are not trying to trick you. They want to see if you can operate as a competent attorney one day. If you study with that, trust me, you will pass. Good luck and study smart. But really, you've got this, guys. We are now counting, oh, it's actually 2 days. 2 days before your exams. And if you follow these tips and you make sure that you remember everything, you will come back and comment that, you know what, Sheila, paper 3 is not as bad as it is, as it seemed to be. Yes, the past mic is saying this. And most of the time, it's not that you go into the exam without the information. You've got the information, but the problem is application. So nonetheless, study smart and pass paper 3. Come back with your comments and be like, it makes sense now. I am doing well. I did well, actually. I did well. October, we need more comments that will say, I passed paper 3. I used your method and I did pass paper 3. Nonetheless, that's it from me. I was hoping this video is 10 minutes, but oh well, it is what it is. Good luck, guys, for your studies. Bye.